Good afternoon, everyone, and welcome. My name is Amanda Coventry-Barrage, and I'm Dying with Dignity Canada's program coordinator. Today, I'm joined by my colleagues Kelsey Goforth and Melissa Mueller. Before we begin, I want to acknowledge that while we are meeting virtually, the land Dying with Dignity Canada is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Indigenous, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 of the Mississaugas of the Credit. We invite and encourage you to do your own research regarding the various treaties, in particular the land in which you're on while meeting with us today. I am thrilled to welcome you to our fifth and final session of Dying with Dignity Canada's Learning Centre, Patient Rights 101. Throughout this series, we aimed to provide comprehensive information on several topics related to death and dying. By attending all 5 sessions of our 101 series, you should gain a thorough understanding of the issues that matter to you. And you can find all 5 sessions of our website recorded. All right, so before I welcome today's presenter, I'd like to go over a few housekeeping items. Everyone on the call is muted. However, there will be opportunities to submit questions. To do so, please type your questions into the question bar on the Zoom side panel, and we will read it out for you at the end. Please try to keep your questions as clear and concise as possible. While we are also going to try and get to as many viewer questions as possible, unfortunately, we may not be able to get to everyone. If you have outstanding questions following the webinar or questions that are quite personal in nature or complex in nature, we want to urge you to contact us at support@dyingwithdignity.ca, and we will follow up with you individually. We will also be sending a post-webinar survey that will pop up on your screen after the webinar. It will give you the opportunity to share your feedback with us. This session will also be recorded, so you'll be able to watch it again later. So there's no need for you to take notes if you don't want to. All right, so now we're going to introduce today's speaker. I'm very excited to introduce to you Ruby Shanker. Ruby is a bioethicist for the University Health Network of Toronto Rehab and Women's College Hospital. She is an adjunct lecturer and co-directs the Teaching Bioethics course in the University of Toronto Joint Centre for Bioethics Master of Health Sciences in Bioethics program. Bit of a long haul there. Along with practice, Ruby is also pursuing doctoral studies in the Health Professions Education Research Program that's offered by the University of Toronto's Institute of Health Policy, Management and Evaluation, along with the Wilson Centre at UHN. She is a graduate of the Master of Health Sciences program in bioethics, and she's completed a fellowship in clinical and organizational bioethics at the University of Toronto's Joint Centre for Bioethics. Wow, quite a resume. I'm now going to pass it over to Melissa, who's going to get us started with the presentation. Melissa?
Thank you so much, Amanda, and welcome everyone today. And of course, welcome Ruby. We're so happy to have you today. So before we get started, because this session is all about Patient Rights 101, we also wanted to share with you that DWDC does have a Patient's Rights Guide, and it covers many of the topics that we're going to be discussing today, and it is a great resource to have. So you can download the Patient Rights booklet from our website, and we have put the link in the Zoom chat for you as well. And if you would like a physical copy of the Patient Rights Guide, please email support@dyingwithdignity.ca, and we can mail one to you shortly. Again, Ruby, thank you so much for joining us today. I know that you have a wonderful presentation prepared, and so I'm going to pass the floor to you to go through many of the topics that surround Patient Rights 101 and bringing in your own experience and expertise in the field. And so, yeah, for audience members, we're going to do about an hour of this presentation, and then we're going to be saving all of our questions from the audience at the end, and we'll be able to go through as many as we can. So thank you, Ruby, and I will pass it on to you to get us started. Oh, I think you're on mute. I think you're still on mute. Oh. Sorry, Ruby, I think you're still on mute. So Ruby, if you're able to unmute, there is a button at the bottom. Oh, there you go.
I think you're back, Ruby.
Okay, good.
Yeah,
For a moment, I was wondering what happened there. I'm just gonna share my slides. Sorry, folks.
No worries, no worries. Okay, perfect. We can see your slides.
Yeah.
So if you want to do a full screen share.
Does that look okay?
Yes, this is perfect.
Okay.
Okay.
All right. So thank you so much for your patience with me, folks. So I'm really delighted to be here. And thank you for that wonderful introduction, Amanda. And thank you, Melissa. It's really an honor and privilege to be here today, to be able to share with you some of the knowledge, some of the experiences that I've had as a bioethicist within the healthcare system, in order to talk about it in terms of patient rights. I think a lot of what we are going to be covering today, they're just some of the basic themes, and there's so much more that we can talk about in terms of specific, circumstances or situations for patient rights. But hoping that our chat, some of what we talked today will arouse in you some more questions, thoughts, insights that we can then cover up in the question and answer at the end. So I know Amanda already gave, we acknowledge traditional charities today. We're starting June 1st. It's Happy Pride Month. It's also National Indigenous Heritage Month, History Month. So I want to definitely acknowledge that I am right now also in Toronto, as Amanda mentioned, the same areas, the same nations, the same folks who we want to honor today on the same traditional territories. I do also want to additionally honor all the folks, all the ancestors, all the elders, knowledge keepers of those lands and waters, from wherever all of us are joining in today, from different places, I assume from across Canada. Very important, as Amanda was mentioning, for us to be able to reflect on a daily basis our identity, what we're doing, and how this relates to our work within healthcare, but also as people accessing and navigating healthcare, and beyond healthcare, actually. So to working against colonialism and towards reconciliation is one of the areas that I look forward to in my own practice as a learning going forward. And if people are interested, as we should be, there's a whole lot of educational resources available on so many different sites, but particularly on the National Center for Truth and Reconciliation, there's a whole lot that one can look at and educate ourselves. So just a few disclosures before going further. I'm a bioethicist, as you would know. My first profession is in medicine. I trained and practiced as a physician in India and in the Middle East in community medicine, and also trained in surgery before I decided to move on to the dark side, if you will, bioethics practice. So a lot of what I'm going to be speaking today is as a bioethicist, and as bioethicists, we often talk about both the legal, the ethical, how the two connect with each other, how they overlap. But of course, anything that I speak today is not a substitute for medical or legal advice. It's information that you can take with yourself, and I urge you to consider it in good faith and consult with your own clinical team accordingly for medical advice. And if you do need legal advice, to look at a lawyer or an attorney. I practice in Ontario, so what I can offer today in terms of knowledge, information is very much based on my experiences within Ontario, but most provinces across Canada, especially when we're talking about legislation, say for instance, the Healthcare Consent Act, the equivalents in different provinces are quite similar. There are some subtle changes and differences. So I urge you to keep a lookout of that if you're not in Ontario and listening to this conversation, this talk today, and maybe reach out. Maybe I might not know in the moment, but we can always have a conversation later on, or bioethicists that you know of might be able to support you in the province that you are in. I do not endorse any commercial products or services in this talk or otherwise also. I do encourage you to think about your values and to discuss them with with those who are closest to you. And this, I think, is a very important aspect of being educated about our own rights as patients, as people who might be navigating healthcare systems. So in our time together, I'm hoping that we can talk a little bit more about bioethics and how do patient rights come together in those aspects. And some of the themes that we've put together to talk about today, these are themes that were suggested to me by Melissa and team as some of the areas that commonly come up in terms of questions, in terms of queries that people have, supporters of Dying with Dignity. We're going to be looking at some areas around informed consent, substitute decision making, advanced directives, and power of attorneys. We look at access to information, healthcare information, treatment options, and around second options. So Melissa and team were very kind to put forward questions under each of these themes to sort of compile a group of questions that tend to come up very often. So you'll see going forward in these coming up slides, these questions feature, and I'll be trying to speak to them. The slides do have a lot of information on them, and they're only there because this is a recorded presentation, and people, I hope, will be able to look at them later on for more detailed views. It's not meant to crowd the slide, certainly, but as a sort of a reference for later on. So hope that it's taken in that spirit. My PowerPoint skills hopefully are not being judged accordingly. So let's go on further. And before we jump into the themes itself, what is bioethics? I think this is a good question to start off with, because a lot of folks don't understand. They know what ethics is, they know what bioethics might mean, but what does it mean in terms of healthcare practice? And this is a question I get all the time, even after a decade of practice in bioethics and in healthcare. So what is bioethics? It is a systematic exploration of questions about what is morally right or morally wrong, or perhaps even better put, what is morally permissible or not. So in bioethics, we're all constantly thinking about deciding what we should do, explaining why we should do it, and describing how we would do that. So it's often about pursuing the best or the least worst option in a complex situation. So not about the right or wrong, or, it's often you have a decision to be made. It's ethically complex, and sometimes we're left with options where all of the options are really bad, really terrible, and we have to choose the least worst option, if you will. And so it can be hard that way. But bioethics as a service, bioethicist as myself, bioethics is usually a free and confidential service that's available to everyone in the hospital setting or any healthcare setting where bioethics is available. So patients and families and staff as well can access bioethics. And we usually aid in deliberating what may be morally justifiable going forward for difficult situations or for ethical dilemmas regarding treatment or care decisions. That's the clinical ethics part of things, but we also help with organizational ethics, research ethics, ethics education. So because of our experience across these various different domains, a lot of cross-disciplinary work comes into play here. Most of us come from very diverse backgrounds. I'm a physician by first profession, but a lot of folks are from philosophy, from theology, from law. So a lot of contributing disciplines and backgrounds. And that's perhaps why we appreciate and approach ethics practice from a very different spectrum of perspectives for decision making, and support patients and families accordingly as well. So ethics, if you want to think a little bit more about just what's morally permissible and what's not, I mean, another way of thinking about it is whose story are we listening to? Just as you can see in this image, you have an elephant and you have a scaffolding of sorts in front of the elephant, and a whole lot of folks are looking at the elephant through the frame in front of them. If none of them have seen an elephant and you were to ask them, describe to me what you see, what an elephant looks like, they're probably only going to be able to look at the frame in front of them and describe what they see. And ethics is about asking each one of these folks, what do you see, and putting together the whole picture to be able to say, this is everybody's perspective to the situation. This is how a whole elephant might be described more completely. Ethics is also about good versus should. Now, any decision that has to be made, there's always things that we can say, no, I can do this, I can do that, but which one should I do? How do I justify the best option going forward? And there are different ways of doing this. We all make decisions based on so many different patterns, the way we've been brought up, our culture, the way we have inclinations towards certain ways of decision making. When we think about values and principles, which is what ethics is about, we might make decisions based on our values, on duties, on the consequences of the action, or some messy combination of them all. Whatever it might be, ethics is about justifying how we make those decisions, the could versus the should. It's about clarifying the values and questioning assumptions that we might have, and to ask the question, is the process of being able to approach the particular situation fair and transparent for all? As you can see in this image, you have a blackboard and you have a mathematician who's worked through a theorem of sorts. Somewhere in the middle, one of the steps reads, then a miracle occurs. And bioethics is about asking, what is that step? Is there a way for us to make that step a little bit more explicit, a little bit more transparent for everyone, especially those who are affected and involved with the final decision to be made, for them to know more about it? Right? So ethics is all of these in different ways and forms. Some of the common ethical themes that tend to come up in practice, and there's so many more than what I have listed here, but I was thinking more about those areas of ethical themes where patient rights come up quite often. These are some of the ethical themes that have come up in my practice and those of my colleagues as well, where patient rights might be at the forefront of what we're talking about. Some of these we'll be going through today. There's consent capacity, substitute decision making. There's goals of care. What do we expect out of the goals of care for a particular patient? There's withholding and withdrawing treatment. There's end of life care very broadly. There's caregiver preferences. Caregiver preferences basically refer to those situations where patients might not be comfortable with certain kinds of healthcare providers providing care based on certain identities or how they present. And there might be two sides of that. It might seem discriminatory in one way, but the other hand, it might be circumstances where patients' rights might need to be respected accordingly. Very briefly, for instance, a woman who might have just been abused might not want to have care being received from somebody who is a male healthcare provider in that moment. And that's something about a patient right situation that we might want to justify and respect, but that's just an example there. And the other ones, as you can see, a lot of these bring up patient rights situations where we really have to think about what is it that the patient wants? What are their rights? How are we respecting their right to make decisions and honor their wishes accordingly? So let's jump into the first theme, which is informed consent. So one of the questions put forward in this theme was, what is informed consent and what is required to determine if informed consent is present? So I'll speak to the context of Ontario as I practice here and I'm more familiar with it. So as per the Healthcare Consent Act, or the HCCA for short of Ontario, and very specifically, there's a section 11 part of it. It describes consent. The legislation describes that consent must relate to the treatment. It must be informed. It must be given voluntarily, and it must not be obtained through misrepresentation or fraud. So as you can see, being informed is one of the aspects of it. And it's often, we don't often stop to ask what informed actually means here, but it's always good to know that the legislation further describes that being informed about the nature of the treatment is part of being able to give informed consent. So you need to be able to know what the expected benefits are, the risks are, side effects of the particular proposed treatment might be, alternative courses of actions, the risks and benefits of each of those, and also the likely consequences of not having treatment, so that you can really weigh your options about getting treatment versus not getting treatment and what that looks like. So these are the elements of informed consent and what constitutes the nature of treatment, information that I think every patient, everybody who's accessing, navigating healthcare should know that they have the right to have about a particular treatment. So next time, if you're not provided with certain alternatives, for instance, or you're curious because that hasn't been talked about, it's a good question to ask. So what else is there other than this proposed treatment? What are my other options? Or what are my options of not having treatment? Or what are the other side effects? Asking those kinds of questions when you know that it's your right to have this information is always good, sort of good practice for yourself. Now, what to expect? So what are some of the questions that you can ask your clinical team as you're trying to consider treatment options? Some of the questions that tend to be that I like very broadly that might be useful when patients and families get together to ask is that what will life look like in 6 months, 1 year, 5 years from now? And this completely depends on the kind of treatment, the kind of health condition that somebody might have. We're not talking about end of life all the time. This could just be a chronic illness. So you just diagnosed with diabetes, for instance, and you want to know what life will look like, how it would change the quality of life and all of that. That would be the kind of question to ask. You might want to know what might be the possible big changes to prepare for. So what am I at risk at? Could there be eventual organ changes? Do I need to be prepared for liver, kidney, like that kind of follow-up, which your clinical team obviously will be looking into, but good information to ask about and be prepared and have that for yourself. Another question is about the ability to function independently. And I think this is a question that we all worry about in terms of how independent one can be. How we each define independence is also very different. Some of us might be completely okay, completely requiring certain kinds of independence in certain spheres of our life, while others might be content with certain areas and the other ones, it's okay. It's a very different, there's no right or wrong answer to this. It's just a preference. It's just how each one of us are built and think and navigate through our own life. And therefore, it's very important to ask your team, this is my understanding of independence. Is there anything going to change because of the illness that I have or the treatment that I'm going to be taking in that sense? Another question is odds of recovery if I choose one course of treatment over another. Recovery, or maybe we're not talking about recovery all the time. Maybe it's just better maintenance of a particular condition. And that might be a question to ask. And what happens if I decide against treatment or any one kind of treatment option? So this is very similar to the informed consents of discussion, the consequences of not having treatment and what happens in that case. These are some of the starting questions to ask that I think your clinical team would then be able to expand on more information. Always good to begin from here. Now, what if someone is unable to provide informed consent? So when we're talking about someone who's not able to provide informed consent, we're talking about somebody who might not be capable of making decisions for themselves. Now we'll come to capacity in a bit, but before we think about, so we all make decisions for ourselves as long as we're capable for the particular decision that needs to be made for our healthcare treatment. But if you're found incapable, and I'll talk a little bit about that in a bit, each province does have a hierarchy of substitute decision makers. So a person who can step in to make decisions on your behalf. So not just anyone can do that. There's a hierarchy based on the Healthcare Consent Act of Ontario. A hierarchy is a rank list. So from you go down through the list, you have to go through the list until you reach the person who's most available and willing and able to step in as substitute decision maker. So as per this hierarchy, in Ontario, the first few people who would be able to be substitute decision makers would be a legally appointed guardian, a power of attorney for personal care, a representative appointed by the Consent and Capacity Board. Now, these are legally appointed people. So if by any chance you've had to go through the court system or the Consent Capacity Board to be able to have a representative appointed, there's a document available and this needs to be provided to the healthcare team. I'll qualify that it doesn't, well, it's always good to have the healthcare team aware and provide them with a copy of the document that names the particular person in these three categories so that they know who to speak with whenever the capacity of a particular decision, the person's capacity is in question accordingly. Now, if three of these folks are not there, there's no legally appointed person. So for most of us, like myself, for instance, if I'm not going to be capable for a particular decision, the first person who might be in terms who can step in as my SDM would be my spouse or my common law partner. Next in line would be a child or a parent, and child or parent are on the same level of the hierarchy, which is quite complex sometimes. So when I say child, to be a substitute decision maker, one has to be 16 years or above. So a 17-year-old child could step in to make a decision for the incapable, parent. But if the patient's own parents are also around and involved, then that pitches their 17-year-old child along with their parents at the same level for making decisions. They have to make decisions together. So as you can appreciate, it can be quite complex sometimes if people don't agree, or 17-year-old kid trying to make decisions. It's hard to do that, and might rely completely on the parents, on their grandparents to make those decisions, which is fine if they're all in agreement. But if not, it can bring up a whole lot of issues in terms of navigating what's next, what's the best thing to do next. After the child or a parent, we have a parent with only right of access, and this is mostly pertaining to pediatric patients in that sense. Then we have siblings who are all on the same level. So if I have 7 brothers and 6 sisters, they all have to come to a decision together. They're all on the same level on the hierarchy. If there's disagreements, then we'll have to look into the process. There's a process in place, actually, if there are disagreements among people who are equally weighted on a hierarchy. And it usually goes to the consent and capacity board again for deliberation. After the siblings, we usually have other relatives. And if there's none of these folks, no legally appointed folks or any of the, the spouse or child or any of them, then we have the Office of the Public Guardian and Trustee, or the PGT, that usually steps in to make decisions on behalf of the incapable person. Now, the PG&T, they also step in if equally weighted SDMs disagree, and that's usually through the consent capacity board, or the PG&T is able to take on before the consent capacity board needs to intervene. The PG&T, by the way, are part of the government. They don't know the patient, right? So when we do approach the office, they will step in, they will ask the clinical team questions about, what did the patient want? Do you know anything about that? And we'll have to make decisions based on whatever's available, which, as you can, appreciate, is a very hard thing to do. They don't know, as like the way a spouse would have been able to say for the incapable person or the child or the parent, the PGT can't do that. This is one of the reasons why a lot of folks who don't have any of the people on the hierarchy don't want decisions being made by the public guardian and trustee either. They do what they can in terms of appointing a friend or a neighbor or somebody who might not fall naturally on this hierarchy, on the automatic SDM list, to be a power of attorney for personal care. That's usually what people tend to do. I've put here power of attorney for personal care because there's in Ontario and in most provinces, the power of attorney for personal care and that of property or finance are two different power of attorneys. It can be the same person. In Ontario, you could appoint the same person to be a power of attorney for personal care and for finance, but they're two separate documents. They're two separate paperwork that you have to complete with witnesses attached. So you can't, just because somebody takes on finances, they can't automatically step in to be power of attorney for personal care. There's a distinction there. So let's move on to now advanced directives, and quite related to what we were just talking, power of attorneys. So I was asked the question, what advice would you give patients who are completing an advanced directive? I think a lot of folks who think about wanting to have an advanced directive or even having a power of attorney done are good on you for thinking about the future and giving this additional thought about your, what you want, your wishes. But it's very important to think about who you might be, like what kind of directions you're giving very explicitly in that advanced directives. There's important implications for the kind of care you can receive, where you can receive, and who is the one who's going to be putting that into action as your substitute decision maker or your power of attorney. It should be an expression of your values, not what you think that your family will be okay with or the burdens it might have. Now, some people do decide that I would like to go for a particular option. It's acceptable to me because it also keeps my family safe and happy and healthy because of that. And that's also very important to me. My family being safe and happy is also important to me. And so based on that very complex sort of way of weighting values, you might make certain decisions, and that's fine. But if it should come from thinking through that decision properly, because otherwise, when this usually comes when you talk about going to a long-term care facility or any other care facilities, people might say, I don't think my son or my daughter can take care of me. I will be a burden on them, even though I'd rather not spend time away from my own home. And that can be such a complex decision to make. It's a very poor vehicle for expressing your love as well, or for mending fences, or for remedying perceptions of favoritism. And here I just want to caution folks, a couple of cases that I've had in the past in my own practice as a bioethicist. I had once come across a very lovely woman who was, thinking about an advance directive, thinking about power of attorneys. We gave her all the information she had, she asked about and wanted. She had a daughter who was quite involved in her care. And at this point, she was capable, of course, but she was anticipating being incapable going forward. She also had a son, but who had not seen her for years. We all thought that she would be, appointing the daughter who's involved. They get along well. She's at the mom's bedside, talking to the team with the mom's knowledge. Everything's going fine. But the mother ended up putting her son as power of attorney because she wanted to sort of bring in the estranged son back in the family. The son, when she did become incapable, the son showed up with the power of attorney. And he'd been so long, out of touch with his family, not knowing what his mother wanted, the discussions that you usually have with your close ones about the values you have, things you want done, those things he was not part of. And so it was a very complex, very difficult situation that everybody was in, including the daughter, who knew exactly what her mother wanted. Her mother had expressed even to the team the same things, but the son was making decisions otherwise. So that's a complex situation when we don't disagree, and it's a power of attorney you've been appointed. It goes to the courts, not necessarily to the consent capacity board. It gets very complex here in Ontario, at least. So just cautioning, think about who you're naming as power of attorney, what you're putting down as advance directives, and if the person who is supposed to follow through with those directives are emotionally and psychologically strong enough to do that, to stand up for you accordingly. Now, what advice would I give patients who are completing an advance directive? You can name more than one person. That's another thing people do. But when you do so, be aware. It's good to have more than one person. They might help each other. They can carry out the burdens. One might be available when the other one is not. But if they have disagreements, they have equal authority, and it can be a difficult situation. Everybody gets stuck. And it can be difficult for the healthcare team to deal with more than one person, especially if they're not available at the same time to talk about decisions, about options, and they have to make decisions together, right? So it can be a difficult situation in that sense. Now, around substitute decision making, again, related to what we've been already talking so far, what advice would I give to a power of attorney or an STM when making decisions on behalf of the patient? And patient here, when thinking about an incapable patient, I think there are a few things to think about here. A lot of times we don't know this because as lay people, trying to be there for our loved ones, if you don't know anything about the healthcare system or the Healthcare Consent Act, it can be that you're making decisions as best as you can. Nobody's asked to step in as an SDM or a POA when everything is going fine and dandy, right? It's usually something has gone through, patient is incapable. It's a very stressful situation already. And it can be doubly stressful when you have to make quick decisions if things are acute. So when you step in, you need to know that a power of attorney or an STM can only step in if the patient has been assessed as incapable for a specific treatment or specific decision being proposed by the clinician. So just because I'm not capable for one particular decision doesn't mean I'm globally incapable for everything at that time. There might be certain things that I'm unable to understand and appreciate, which is the ability, the capacity, my capacity for healthcare decision-making is based on the abilities to understand and appreciate information related to the proposed treatment. And there might be certain kinds of information, certain kinds of decisions where it's too complex for me, and some of the other ones that are quite simple. So nobody's globally incapable unless you're unconscious or you have a health condition where absolutely not able to talk or be part of decisions in that sense. It is a clinical assessment, capacity assessment. So it's the clinician who's proposing the treatment or the decision that has to be made by the patient. They have to assess the patient, whether they're capable or not. Decision capacity is also decision specific, as I was mentioning, and time specific. So if I have mild cognitive impairment or the beginnings of dementia, for instance, there might be times in the day that I'm actually quite lucid. I'm able to make decisions completely. And then other times when I'm not so much. So it's important to make sure if you find when healthcare providers usually come across patients, they are supposed to, and they do often, make sure that the patient is not having any, there are no factors that are affecting their ability to, be capable for that particular decision in that specific time. And if things can be optimized, if the capacity can be optimized over time, that's something what healthcare providers usually try and do. And so this is good information for us to know as power of attorneys or STMs. You don't step in completely always. It depends on the particular decision. Not every decision you would have to step in then, unless, of course, the patient is in a particular state where none of the decisions, they're unconscious and they're not able to make decisions in that sense. Now, in terms of making decisions on behalf of the patient, I think, so the Healthcare Consent Act in Ontario, as particularly Section 21 talks about, when making decisions on behalf of incapable patients, it needs to be based on known values and beliefs. So the patients, whatever their values and their beliefs are that are known to the STM or the POA. Any prior expressed wishes. So advanced directives fall under this. If they've written something down or if they've already talked verbally to somebody about what they wanted about a particular treatment or situation, then that decisions have to be based on that. The STM also has to make decisions based on if the treatment that has been proposed will improve, maintain, and certainly not deteriorate the condition of the patient further. And similarly, if no treatment will do the same in those sense. They have to think about if the benefits of the treatment outweigh the risk of harm. So the treatment should definitely be able to, we should be able to say that the treatment is going to be making things better for the patient or maintaining the patient and not deteriorating, obviously, given the risk of harms present. And if there's a less intrusive or less restrictive option that is available than the proposed treatment, that's the one to go with. We have to inquire about that and see if that option might be better to go with. And all of these come under what is known as the best interest standard. So as an STM, I can't step in for my mom and say, it's not convenient for me to be able to oversee the consequences of the decision, so I'm just not going to consent to it. I have to make decisions based on what's good for her, what's best interest for the particular patient who is incapable, not for the STM. No matter how inconvenient it might be. That's what the best interest standard talks about, and that's what the Healthcare Consent Act in Ontario puts forward. The Healthcare Consent Act of all the other provinces also have very, very similar ways of making decisions, and some are actually even more detailed and more pronounced in that sense. So what happens if I don't name anyone? So if I don't have anyone or I don't name a POA? So without a POA, your legal SDM, the person who's highest on the hierarchy, becomes your substitute decision maker, as we saw a bit earlier. As I mentioned very quickly before, there are criteria to be an STM. You have to be over 16 years old. You have to be capable yourself of making healthcare decisions, of course. You have to be willing and available to the team to be able to, be available for decision making, information sharing, etc. And you have to make decisions based on the previously expressed wishes, values of the patient, and best interest standard, as we mentioned and talked about. If there's nobody you name, or if you don't have anyone on that list, we talked about that as well. The Office of the Public Guardian Trustee steps in Ontario, and there's similar offices like that for every other province as well. So when you do name somebody, when you do have a POA or you have advanced directives done, it's so very important to review and reflect on them periodically. So when there are major life changes like births or deaths, marriages or transitions in the family, it's important to pause and say, the wishes, the values that I sort of had in my advanced directives that I've shared with my SDM, my POA, have they changed? Do I have I evolved? We all evolve over time, but has it evolved at this moment? And do I need to make those changes? You might also want to reflect on changes in your advanced directives or to your POA, if there's a change in a health status, if you change your mind about your wishes completely, or maybe there might be completely new information available and you might want to update it. It's a good practice, if none of this is happening really, to review and reflect on your wishes, on your advanced directives, on your POA annually. That's at least the minimum that we might need to do, if not sooner. So let's jump to now access to information. So access to healthcare information. So one of the questions asked was, can you speak to a person's right to access health information? How does that work? So as patients, as people navigating the healthcare system, seeking healthcare, we do have the right to access health information pertinent to us. These days, what happens is most healthcare organizations where we seek care at, or clinic offices that we have, they usually have electronic patient records, or they do have a patient portal of sorts that through which patients can access some amount of the information. This is quite new. I think in the last maybe last decade, if I can say, that this has having patients be able to access the information through patient portals of the healthcare system, healthcare organization. And initially the information was quite limited, but most organizations have moved, at least in Ontario, to make it more expansive, much more detailed information. You might not have access to very detailed clinical notes that clinicians might put into your chart. However, if you are curious about some information, you think that there might be something incomplete, or you just need to see information that's mentioned and have it ready for accessing some other kind of care that's dependent on this information in your chart, you can always ask the healthcare organization to access it. There's usually a very small fee or something of that sort to photocopy. In the past, maybe now there's no photocopy fees because it might not be paper copies. They might be able to make it electronically available to you, but it's a matter of asking and saying, I would like access because it's my health information. You're the custodian of you are the owner of your own information, and everybody else as healthcare professionals are only custodians of that information. That's good information to keep in mind. Can anyone else access your health information? Well, so we do have legislation in Ontario, the Personal Health Information Protection Act of Ontario, or known as PHIPA for short. And this is a very detailed, very complex legislation that does, put forward the rights of patients and persons accessing and seeking healthcare in terms of being able to have the rights to their own health information. So no, not anyone can have access to your health information. The clinical teams that are directly involved in caring for you, clinicians involved in that, and people who might be indirectly involved in being able to provide care to you as well. It has to be related to the care that you're receiving, even if it's between organizations. Only they can access your health information, and this has been described in the PHIPA legislation and several other documents that come out from the privacy legislation in that sense. Within Ontario, I'm speaking, but every province has its own sort of group, its own legislation accordingly. You can have electronic record access provided or made available just as you have your patient portal. You can share that with your SDM, with your POA. That's based on you giving them access, and you can certainly allow or restrict access to information. So for a very long time, we've had things known as locked boxes, where we are able to keep certain parts of the health information or the patient chart locked or not available for even the clinicians to see. So sometimes we've had patients who've had mental health conditions who do not wish to have certain aspects of the mental health condition known to every member of the clinical team who might not be looking into their mental health care, and mainly because they have feared being prejudiced because of their mental health condition. When it comes to physical conditions and having concurrent sort of conditions like mental health and physical health, there's a lot of oppression often faced, and people have chosen to restrict access to certain kinds of clinicians accordingly. And you can do that if you feel so. It's always good to ask questions like, why do I feel uncomfortable? Like, reflect on it, obviously, and to see if there are ways in which you can find information with your clinical team to be more comfortable with them having information having access to your information. But if not, there are ways of doing that by accessing the health records department of the healthcare organization that you're seeking care at. They usually are able to provide more information and the specific process involved in the healthcare organization that you're accessing care at. So in terms of treatment options now, so in terms of treatment options, these are the questions that were put forward. Advice to be given to patients who are navigating treatment options, and how can patients request a do not resuscitate order? Now, I think these are very, very important questions to ask your healthcare team, your clinical team, in terms of the do not resuscitate order. If you are thinking you are experiencing, or you do have a chronic illness, or you are thinking about the situation where you might have a cardiorespiratory event, and you do not want to be resuscitated in that sense, it's important to have that conversation with your clinical team, with your family doctor, with your whoever's providing care to you at this time, and have that discussion to say, what are the options here? Will I be in a circumstance where a do not resuscitate order would be useful, or should I be looking for CPR? Like, should I be looking for resuscitation? What are the options here? What are the consequences of going through each of these? You can request a do not resuscitate order, which is something, there are two different things in Ontario. You can have a community, there's a form that your family doctor can fill out for you, or a caregiver in the community, health professional in the community can fill out for you, which is also known as a do not resuscitate order. It's an order that is meant for paramedics, for emergency services who might be accessing you in your house or wherever you're living, to be able to see and say, okay, you're going through an event right now. Somebody has called 911, but you, in fact, do not want to be resuscitated. If they don't see that order in your house, so it needs to be prominently displayed somewhere, they will still proceed to resuscitate you and provide you care and reach you to a hospital emergency as soon as possible. So if you do have a community do not resuscitate order, you want to make sure you are displaying it quite prominently somewhere on the fridge or somewhere in the house. So, like in the event someone at home did just decide to call 911, at least your wishes in terms of a do not resuscitate order can be respected and honored. Of course, if you are the one calling a 911, and hopefully you're conscious in that moment, they will be able to recognize that you've called out the order and you still have a do not resuscitate. They might err on resuscitating you in that moment because you've changed your mind clearly by calling 911, even though you have a do not resuscitate order. Now, that order is not the same as what you might have inpatient. So when a person might be in the hospital, you're an inpatient in the hospital, in the ICU or in the medical ward, and so conversations have happened. You're at a stage in your health condition where it has been determined that if you were to have a cardiopulmonary event, or a cardiac arrest, or something that causes you to arrest, then trying to resuscitate you might not be beneficial. And that's a very important discussion to have, very crucial conversation. It's not just a blanket statement or decision made by one person. It is a discussion with the patient, with the family, the STM, with the teams, clinical teams involved. But once that is there in place, that's within the hospital. A form that you might have in the community would not apply, or it would be revisited once you're in the hospital. But what you had in the hospital, and if you happen to go back home after the care that you received, and you still call 911, you would still receive care and be resuscitated, because the do not resuscitate order in the hospital does not apply in the community. Whereas the community one, will be revisited in hospital, but not the other way around. It's a little complicated, but if you find that these questions get difficult, you're asking questions, trying to find out more information about this with your clinical team, and you feel a bit dismissed or it's challenging, or the team does not know themselves, ask for the bioethicist who is supporting the team in the particular healthcare organization, or even the patient advocate who should be available at every healthcare setting or organization. Further questions around treatment options. So what are a patient's right when requesting medical treatment to stop? You have the right as a patient to say, this is it, this is enough for me. I've had the chance to go through some treatments, or I haven't had the chance to necessarily try out the treatments, but I just don't want to go through with this kind of suffering, or the information provided to me about the kinds of treatments available to me in this moment don't seem satisfactory. So I just don't want to do it. I would like to stop whatever's there. You do have the right. But when you do that, it's important to consider all the information that you have in front of you to be able to think about this in an informed decision, as an informed decision. So under the same thing, in terms of stopping treatment, some people might choose to voluntarily stop care. So, maybe in hospital, they don't want any kind of care, not just food and, drinking and eating, but also care regarding, antibiotics if they had an infection or so. You can stop all kinds of care, or you can voluntarily stop aspects of your care. And this is a discussion, again, that needs to be had with the clinical team so that they know exactly what you're asking for. By stopping certain things and continuing certain other things, how do they interact? What effect they have on your health, on the outcome of your condition, that in the end of it all. Some of these situations where people might opt to voluntarily do this, usually end of life. We see this very often, people suffering from end of life conditions, where they've had treatment or had a whole host of treatment. It's weighing them down. There is not much in terms of relief. There's some symptom relief, but they're not able to reverse their health condition or like cure. Recovery in that sense is not there. And they would voluntarily want to stop care, or stop eating or drinking because it's uncomfortable for them. And they just would like nature to take its course. And that's completely fine. If that's the wish of the patient, if that's something the patient has expressed previously to their STM, to their POA, so that they can act upon if the patient becomes incapable, and inform the team that this is the wishes of the person, that should they reach a particular state in their healthcare, in the trajectory of their illness, that they would want to stop care, certain kinds of care, or they would want to stop eating or drinking, and we're fine with that. Right? So that's information you have the right to stop, but it's a very crucial conversation to have earlier on, maybe something to even have when you're thinking about advanced directives, very early on to have with the SDM POA, and keep revisiting it, because we evolve in the way we think, we evolve as our health status changes, we evolve when new information comes up, right? So second opinions. When and how should a patient request a second opinion? Usually when patients request second opinions, it's because either they're not satisfied with the response they've got from the first clinician. Satisfied in the sense it could be that they're thinking there might be more here, right? Do I just make a decision about my life based on one opinion of one clinician? After all, there's clinical judgment. What about asking a couple of other folks to see if everybody's thinking the same, right? So it's assurance that we're looking for. It's validation we might be looking for. Or unfortunately, in certain circumstances, we might come across a clinician who hasn't provided us with enough information, or our efforts to ask more questions, to gain more information, have not been very successful with them. And so you might want to ask another person, another clinician, for their opinion. After all, the decision that you have to make it's very important. It's life and death in many ways. It's treatment that can affect your quality of life. And you are entitled to have a second opinion. Is there a limit to how many opinions you can get? Nothing prescribed in the legislation. There might be hospitals, or there might be healthcare settings that do describe it. I haven't come across them in my experience. They might do that just because they see that very often in particular areas of care settings. There's no limit. But the question is, how many do we want to go through in terms of second opinions and subsequent opinions as patients? Sometimes and I've experienced this myself as a patient who's navigating healthcare systems, for various health conditions. Sometimes I want to ask a second opinion because I'm stalling. I know that I might actually say yes to the particular treatment being proposed, but I'm stalling because I'm scared. I want to know if other people also think the same. And there's a point after which that asking for several opinions and you're getting the same response from every clinician, takes some time. It takes away time from being able to even try that particular treatment or go ahead with that decision. And that's a fine balance that we have to keep in mind in terms of timing. But you are entitled to ask for a second opinion. What if, can patients ask for a referral if their doctor refuses to assist with their request for MAID? Now, I have been speaking very generally about second opinions for any kind of treatment, but with MAID, this includes MAID as well. You can absolutely ask for a referral if a doctor refuses to assist. You should, in fact, go ahead if that's what your wish is. if you do want to request for MAID, and if your doctor or your clinician has refused to assist you with it, in Ontario, we do have the provincial line, so you can go through the provincial line to be able to request for MAID if you find that your clinical team has not been supportive. But you can also ask for a second opinion if a doctor has assisted you and taken through your request for MAID and found you not to be eligible, and you disagree with their their eligibility, sort of the way they've presented it to you. You can ask for a second opinion and see what the next clinician sort of goes through. Again, the provincial line within Ontario for MAID can be very helpful for this as well. And going through there, if you find your requests or referrals have been dismissed in the past, it's a good chance to go through the provincial line and see what they can do to help you. So some of the reasons that you might want to go ahead with the second opinion, whether it's MAID or any other kind of treatment decision, you really want to make informed decisions, right, based on well-supported clinical judgments. On the flip side of things, the cons of it, you might be questioning the judgment of your clinical team. And it's okay. I think most healthcare professionals are quite secure in the knowledge that they have, and they welcome the opportunity to double check with the colleague even, to be able to see that they're providing the best care they can to you as their patient. But it's a fine balance if you keep on asking for opinions, and every time you meet with that particular patient, that particular clinician, you haven't trusted their judgment and you keep asking for a second opinion. It might be time to think about having a different care provider altogether, because there's a trust issue in that situation, in that relationship, right? And it's a good thing. Maybe that's where we realize that we need to have another healthcare provider and have more trust there to be able to rely on clinical judgments that they make. And this is nothing to say about the clinical judgment of the first person. It's just that maybe we haven't found trust. We need to find it elsewhere. So in all of these circumstances, how can a bioethicist help? A bioethicist supports patients or clients, families, and healthcare providers in critical reflection. So as I mentioned before, deciding what we should do, why we should do it, and how we should be doing it. And we do help with values, with questioning assumptions. We try and help share better understanding. So clinical teams, the patients, the families, they're all on the same side of things. We all interpret things very differently. We have our own perceptions, our own perspectives. And having a bioethicist involved usually is about asking questions, whose story are we listening to, who's being excluded. We bring attention to the relations of power that might be there in the particular clinical encounter, and raise the voice of the patient to be able to say, this is what the patient is saying. These are their rights. How do we make sure we can respect, honor, and fulfill them in the best way possible? It's also about deliberating the could versus should. We need to be able to justify our decisions for accountability, and decisions, not just the patient's decision, but clinical decisions for accountability, to be able to say to the patient, you have access to the best care, the most compassionate care possible from us. So that's about it that I had for us today. But I think we can move into the question and answer session, and I'm looking forward to questions that people might have. Just want to say that whenever you speak with the bioethicist, we often like to have a safe and open moral space. We go by the principle of conversational charity, which means assigning the best interpretation to the words and actions of the other person, even if we don't agree with them initially. So disagreement is good. We want to hear diverse opinions always, but we also want to be kind. We want to be charitable. We want to be reciprocal. We are all experts in different ways, but we're also human in limitations. So it's good to learn and share with each other. And with that caveat, I'm going to go into the question answers. And I see Melissa is here.
Thank you so much. That was perfect timing, 4 o'clock on the dot. So that was an amazing presentation. I know it kind of just scratches the surface to a lot of the issues, but I think it really gives the audience, a broad understanding of patient rights and the different areas that are involved, and especially your expertise and experience really helps with just working through this information. So the first to talk about is we did have a comment from the audience about substitute decision making and the age. So just to clarify, or just to remind everyone that Ruby, it works in Ontario. So you're speaking as a bioethicist in Ontario, and to be a substitute decision maker in Ontario, you have to be at the age of 16. However, that age can vary depending on other provinces. So I just wanted to clarify that. We had an audience member want that to be clarified. And so staying on the topic of substitute decision makers, we have a question. I've heard of cases where substitute decision makers advises the healthcare team of patient's advanced care directive and wishes only to be ignored. What should an SDM do in this situation?
Yeah, I think that's a tough situation to be in. So oftentimes you have, so I'm just sort of reiterating if I understood correctly, Melissa. I think the question is about a substitute decision maker who might be a POA as well, has information about the patient's wishes, their advanced directives, and is providing that to the clinical team, but is being ignored about it. One thing might be, maybe the patient, I'm wondering, because there's so many different perspectives always in a particular situation. You can feel ignored because that's what it is in that moment as an SDM. It could be that the healthcare team has listened to the advanced directives, the wishes, but it might not be applying in their perspective to the particular decision to be made. It might actually apply, but they are thinking of it as it's not applying here, and therefore it seems like it's being ignored in that sense. What is necessary in that is a conversation to say, I've given you that information. Why is this being ignored? Don't you not think it's applicable for this particular decision? Yeah, I think so. As the SDM, it is applicable. And to hear what they have to say about it. If at any time an SDM or a POA does feel like their wishes or their ability to function as an SDM on behalf of the incapable patient in Ontario is not possible, they can go to the Consent and Capacity Board to be able to have this conversation with them. The Consent Capacity Board, there are different processes. It's quite a complex situation, so I don't want to talk too much about it right now, but the Consent and Capacity Board is there in Ontario to be able to help families and patients to really come through and make sure that incapable patients are well supported, capable patients are well supported in trying to be able to make decisions as equitably, as justfully as possible. So if an SDM, there are different forms that one can fill out and go through it, and this is something that the bioethicist of an organization or the patient advocate of the organization can also help. So the first step might be to say, I feel ignored here. Healthcare team is not listening to me. I would like the bioethicist involved. I would like to speak with the bioethicist. Most hospital settings in Ontario, for sure, I know in other provinces too, almost all healthcare settings, healthcare organizations do have a bioethicist on site, or at least access to an ethics service, or by contract an ethicist. So you should be able to have access. The question is to ask, can I have the bioethicist or the patient advocate involved? Right.
Perfect. Thank you so much. So another question that we have, could you provide info on how a patient could raise their wish for VSED, which is voluntary stopping eating and drinking?
Can you just repeat that once again? I think you cut off a bit. Yeah.
Could you provide info on how a patient could raise their wish for VSED?
Oh, yes, of course. I think it's a very tough decision, right? I think even for a patient to come to that point to say, you know what, I'm at that trajectory in my condition that I would like to voluntarily stop eating and drinking. It's end of life, usually in these circumstances. And it might not be something that their family, their STM also might be agreeing with, or the healthcare team who might be so focused on recovery, on cure, and doing everything possible. This might be a whole different sort of mindset. But I think it's so crucial to come forward and say it to your team, I am considering voluntarily stopping eating, drinking, or stopping some aspects of my care for that matter. And this is why. Sometimes it could be that we are not completely, we're not completely informed about our situation, and we think we're in a moment where we want to stop eating and drinking. But there might be information that the team might be able to say, no, actually, you can do better. Like, there's things that we can do. And the team might say things to help you continue with your treatment, because that's how they might be geared toward. They're geared towards curing, recovery, and all of that. And you truly are at the end of it, like, you really want to stop. Then it's about considering the information they provide you with and still saying, I've considered what you've said, but I still think this is the end in terms of stopping to eat and drink for me. And being able to say that it's useful when you have somebody else, either you're a capable person who's making that decision, but somebody who might at some point step in to be an STM, if you were to be incapable, having them involved early on as well, just to be able to voice it along with you might be useful. So you're still capable, they're not making decisions for you, but if you were to become incapable, they would step in. So having their support too in that moment to stand up and advocate for you can be a very useful thing. Again, this is a circumstance where you can get the bioethicist patient involved. You can absolutely ask for the bioethicist, the patient advocate, or the patient relations person who might be a representative, who might be there in any hospital setting that you're in. And they would be also able to sort of bring people together to say, this is a person who's asking, this is their wish. Why are we thinking otherwise? Is there more information we haven't looked at? And how can we honor the wish of the patient in this circumstance, right?
Absolutely. It's definitely a big decision that needs to be, thought out and considered by the patient and also working with your team. So that's perfect. Another question that we have is, what if a GP wants to order tests, but the patient does not want any additional investigations? Can the patient refuse those tests?
Yeah, I think so. Yes. I mean, I think it will be, the question will be that the GP themselves will ask why. I think in your particular circumstance, in the GP's clinical judgment, they might say something like, I think you might benefit from these tests in these particular ways, and they should be able to give you a justification. It's any kind of treatment in that sense. And if you feel like that doesn't match with your own wishes, your own way of thinking about how you should proceed with the condition at this point, or treatment with your condition at this point, I think it's a moment to say, no, I don't want further, because I don't want further care in that respect. I think the conversation then should move towards saying, okay, but your condition naturally might lead to certain side effects or discomfort or symptoms. And how do we manage that? That would be then the right conversation to move into, as opposed to going on and saying, why no testing and all of that. So hopefully a GP listens to what you have to say and can provide you with that comfort and guidance accordingly.
Another question that we had is, how can someone pre-arrange, so if someone is unable to speak, so how to pre-arrange for not being able to speak / ask for an assisted death if their loss of speech is, if they're unable to communicate by speech or handwriting?
Yeah, I think we've seen that quite often in terms of folks who are, they're capable, they can make decisions for themselves, but there's issues with speech, maybe because of a stroke or whatever the conditions might be, or they're not able to write and provide their wishes. Speech language pathologists are awesome at helping out with alternative ways of communication usually. So every team, I'm presuming most folks who might have a speech impediment and are in hospital settings and are considering assisted dying, they would have access to a speech language pathologist. But if not, asking your clinical team who primarily provides you with care for access to a speech language pathologist might be the best way forward. If you're in a hospital, it's quite easy to just ask for a speech language pathologist to be involved. There might be ways if you have other support systems, your friends, your families with whom you might have already established an alternative way of communication, for them to have the speech language pathologist involved. Again, nothing working, ask for the bioethicist. It's, ask for the bioethicist. I mean, there has to be an alternate way of being able to communicate that as well. But asking about assisted dying can be quite challenging. Even if you've made up your mind, the question itself makes it surreal and difficult to see what people might react to it sometimes. You don't know what your team might react to as well. So going to the bioethicist is not a bad idea. Speaking to the speech language pathologist to have an alternative way of communication by which they have devices, they have so many techniques to be able to provide that different ways for people to communicate. And that can be quite actually liberating in so many ways to access information.
Yeah, I do believe we had a speech language pathologist in one of our earlier sessions. I believe it was Capacity 101. So if anyone is interested in, learning about how that speech language pathologist does her work when working with patients with MAID, feel free to check that one out. So another question, a common theme that we usually get with our supporters. So this individual asks, my mother is in long-term care with dementia for 5 years, unable to talk or recognize us. What are the family's rights to end her suffering?
Yeah, that's a tough one. I think this is so advanced dementia, but everything else seems to be going okay. So they're living, they're surviving, they're there, but not really there because they can't communicate and all of that. At this time, we don't really have a lot of options for advanced directives yet, unless it's already done by the patient when they were capable. So we have that bit in legislation for MAID, if you're thinking about assisted dying in that sense. But in terms of other kinds of suffering, like I don't think ending of life is a possibility, or maybe voluntary stopping of eating or drinking might be something, especially because some patients who have very advanced dementia might automatically themselves refuse eating and drinking. It's a reflex. It's sort of the way body's way of naturally going down that path, and seeing those cues and signs might be one way of being able to say, you know what, maybe not to force our loved one to eat and drink when they're clearly like saying, or even though they are in advanced stages of dementia, might be one way of letting nature take its course, but also thinking about the different symptoms they might be having, trying to keep them comfortable throughout any of those symptoms might be one way of dealing with it. If they did have an advanced directive and they were capable to say at some point in my dementia, I would like to access MAID or assisted dying, that's one option to sort of think about. Maybe the time is here, we have the advanced directive in place. Maybe this is the point to sort of bring it up and rethink it. But oftentimes it sounds like this might not be a situation of that, and it's tough. It's really tough to have to see a loved one go through that. They're there, but they're not really there. And, it's hard. So for the person who's asked the question, I'm really sorry that's the circumstance people are going through at this point. But this might be discussion with the team to see, are there cues from the patient, from the mother, in terms of not wanting to eat or drink, just they themselves refusing things. We can follow through in terms of letting nature take its own course, but providing care and support and treatment for any symptoms so that they're comfortable at every point, without having to go through that kind of suffering, right?
Thank you. So we have, we're almost out of time. So I have one final question that I wanted to ask. So what are some, or just one or two, don't have to do or go into as many. What are some of the most difficult ethic questions that you've had to deal with as a bioethicist?
Oh, so many, so many. And like it depends even on the kind of ethical theme that we talk about. I think it won't be a surprise to folks. I think medical assistance in dying itself has been one ethical theme where you can have so many different complex situations, people struggling with eligibility itself, maybe because they have mental health conditions in the past. They're capable at this point, but people are like wondering, is it suicidal ideation? How do we account for the history of mental health in the circumstance? And the clinicians might they've called me in as the bioethicist to be able to think through their clinical judgments and the justifications being made. Are we doing it based on the right values? Are we following the legislation correctly, interpreting it properly? Not so much these days, actually, but in the beginning, when the legislation came out in 2016, a whole lot of that was happening. But I think some of the more complex ones tend to be complex and difficult ones are the more day-to-day ones where you have, say, for instance, discharge planning or transitions in care. So somebody's in hospital wanting to go home, but really their care needs require them to be in a long-term care facility. They don't want to go, they want to go home, but family who's at home are unable to care. They don't want to say that because they feel like it'll be ungrateful for them to do that. The adult children might want to care, but they can't because they have their own lives. And having to get everybody on the same page of the same book, sharing understanding about what the patient wants, what the patient wishes, and how do we accomplish that without everyone having to lose so much in the process. Oh, it's hard. Those are hard and really heartbreaking, I have to say, because people suffer and sacrifice so much on the basis of family. And at the end of it all, it would have been so much more easier if people had just talked to each other at the beginning rather than being quiet and silent about their emotions. So bioethicists can help with that. I've been part of discussions that way. Not all of them go the right way, obviously, but I think most of the times we've helped people realize and talk to each other, have better understanding, at least for the future. But those have been some of the toughest ones for sure.
Absolutely. Well, it's very important, the role that you're playing. And yeah, it's definitely, there can be a lot of challenging, cases and situations that you have to deal with. So, thank you for playing a role in helping those families as best you can. And so that wraps up our webinar for today. Thank you so much, Ruby, for speaking. Your presentation was fantastic. And answering all of these questions. I know a lot of the audience, I'm sure, is learning a lot, absorbing all of this information in. And thank you so much for your experience and guidance. And so this,
No, thank you so much, Melissa. I was just gonna say, I'm so thankful that I could be here with all of you and share what I had. I mean, I wish, we would have done this as a webinar, maybe pre-COVID too, but I wish if everybody was in the room together and there would have been an opportunity for me to learn from everybody else too. This is more, it felt more one directional, but that's okay. I've learned from the questions people have asked and to know, like, what people are thinking and how this might be of support to them. I really do hope that folks are able to go back to the recording, look at some of the information, and my email address is there in it. I'm on Twitter. So if people want to reach out individually, just to chat and talk about things and see if there might be ways for support, I'm available to folks. Thank you, Melissa.
And I do want to let you know there are a few audience members who are chatting in saying thank you so much. Your information was very comprehensive and you provided a lot of clarity. So thank you. That's some of the messages that you've been getting. Yeah, thank you again. And so this concludes the fifth and final session of DWDC's Learning Center. Again, all sessions are available on our website and you are able to view them at any time. And please keep an eye out on our website for any upcoming webinars that we have. And just another reminder that there will be a post survey pop-up following this webinar, and we encourage you to take a few minutes to fill it out, as we always appreciate. So thank you wherever you are in Canada. I hope you have a wonderful rest of your afternoon. And again, thank you, Ruby, and everyone take care.
Thank you.